Hello friends, in the series on the income tax cases, today we will discuss a very important case on the constitution of the tribunal in case of Prevention of Benami Property Transaction Act 1988. The name of the case is VASANTHAKUMAR versus Union of India. This case has been reported in 444 ITR at page number 677 and the matter has been decided by Madras High Court. The date of the judgment is 1st April 2022. In this case, the petitioner went to the writ court for challenging Section 32 subsection 2 clause A, which says that the judicial member of the tribunal constituted under the Prevention of Benami Property Transaction Act will be a member of the Indian Revenue Services who held as a post of additional secretary or a post equivalent to that. The petitioner was challenging this on the ground that no one can be the judge in its own case. There is a separation of powers between the three organs, that is executive, legislation and judicial functions. It is a settled law that one should not enter into the work of another and they should work separately. If the executive will try to take the power of the judiciary, then there will be a chaos in the principles of natural justice. There is a very famous case of India, Nehru Gandhi versus Raj Narayan. In this particular case, the Supreme Court has already held that no member of Indian legal services can be the judicial member of any tribunal. The court has said that in that case, that only the judge or a member of the bar can be appointed as a judicial member of any tribunal. By following the same principles in the Patent Acts also, the constitution of the tribunal has been challenged, and in that case also it has been upheld that no member of Indian legal services can be a judicial member of the tribunal. Similarly, in the CGST Act also, in section 109 and 1110, there is a provision that a member of Indian legal services will be the judicial member of the tribunal. So that has also been struck down by the court. So on the same principles, the petitioner was before the Madras High Court, and the Madras High Court, by following the judgment of the India Nehru Gandhi versus Raj Narayan, which was subsequently followed by two other judgments, one in the patent case and one in the CGST Act, on the same principles, the court held that only a judge or a member of the bar, that is an advocate who has an experience of 10 years, can be appointed as a judicial member of the tribunal, and no member of the Indian legal services who has been appointed as an additional secretary or who held as a post of additional secretary or equivalent post cannot be appointed as a judicial member of any tribunal. Friends, sometimes it happens that we take our matters very casually. So when these type of judgments come, so it reposes the confidence of the assessees and the general public in the judiciary system, because to make the judiciary system independent is very important. Only then we can expect the very good judgments, because we have seen that in this case also it has been held by the court that tribunals have taken the burden of the high courts and they are giving very good decisions, and we have seen that when the tribunals in the income tax gave the judgments, so maximum 90% or 95% of the cases are being upheld by the high courts, whatever the decisions have been given by the tribunal, meaning thereby that those judgments remain the same. Only in some cases the judgments are reversed. So it means that the tribunals are going on the very good lines and they are giving very quality judgments So in this case, the constitutional validity of section 32 subsection 2 clause A of the Prevention of Benami Property Transaction Act was struck down by the Madras High Court. Friends, at the end of this video, once again I am repeating the name of the case. The name of the case is VASANTHAKUMAR versus Union of India, and this case has been decided on April 1, 2022. The matter has been reported in 444 ITR at page number 677. Thank you, friends.